So friends, welcome again. I shared you a very short video on company's account. Here we shall discuss slightly in detail, right? So basic features. As a banker, we must know what are the features of company's account, what documents represent what we have to see in those documents. We shall discuss here. Okay. So we have two types of company's account. One is private limited company and public limited company. So Section 3(1) of the Companies Act 1956 defines a company as a company formed and registered under this act, an existing company, right? So that is as per this has to be registered, right? The registrar of companies. Joint stock company is a voluntary association of individuals for profit, that we call it joint stock companies, having capital divided into transferable shares, the ownership of which is in the condition of the membership. From the above definition, it can be concluded that companies registered association which can artificial legal person having independent legal entities. So, like in partnership and proprietorship, we have entity associated with the individuals. Here it is a separate entity. The joint stock company is a voluntary association of individuals for profit. And it is an entity with perpetual succession. A director may die, director may resign, may leave, but this company's account goes on forever. A common seal for its signatures and common capital comprising of transferable shares and carrying limited liability. Characteristics of a company. So it comes into existence when there is a date of incorporation is there, right? So for forming a public company, at least 7 persons have to be members, and for a private company, at least 2 persons are to be required, right? These persons will subscribe their names to the memorandum of association and also comply with legal requirements of the act in respect of the registration to form incorporate a company without a limited liability, right? So it may be noted that connection that section 11 provides that association of more than 10 persons carrying on a business in banking or an association of more than 20 persons carrying on where other business needs must be registered with the Companies Act. So if the members are more than 10 in case of banking and more than 20 otherwise, it has to be registered with registrar of companies mandatorily. So it's an artificial legal person, right? So a company is a legal person like a natural person. It has the right to acquire, dispose property. So it's a separate legal entity, separate from its shareholders, directors, or promoters. So it is a perpetual existence, right? Directors may come, may resign, may leave, right? Or may, you can say, they may be deceased also. The company's account continues forever. There is a common seal which is to be affixed when loan document are executed in favor of the public limited company or private limited company, right? So that is a common seal. Embossing seal is there, we call it embossed, right? Limited liability. Company may be limited by shares or limited by guarantee also, right? In a company limited by shares, the liability of members is limited to the unpaid value of the shares, right? So remember this. In company limited by shares, the liability of members is limited to the unpaid value of the shares. So sometimes shares full values are not paid. For example, if the face value of the share in a company is rupees 10, member has already paid rupees 7. He can be called upon to pay not more than rupees 3 per share during the lifetime of the company. In a company is limited for guarantee, the liability of member is limited to such account as number of members may undertake to contribute to the assets of the company in case of being wound up, right? To guarantee, in case it is being wound up to whatever they can contribute to the assets. Shares are transferable, they can be sold off in the public, in the stock exchanges. A difference between companies and partnership. Very briefly and very salient features: mode of creation by registration, partnership by agreement, legal statute, legal entity distinct from its members, perpetual succession is there. Firms and partners are not separate, no separate entity. So they are jointly and severally liable, means individually also they are liable and jointly all the partners are liable jointly also and individually also. So here you can see limited liability of the members in case of company, but partnership, unlimited joint and several liability of the partners. Authority, divorce between ownership and management, representative management, rights to share management, common and ownership. They are implied authority, mutual agencies, right? So that authority is implied. Transfer of shares, public companies, they can do it, but in case of partnership, they cannot transfer their shareholding. The types of companies, classification of companies by mode of incorporation, chartered companies, right? So there's some examples are given here: statutory companies, chartered companies. We will not go into very much details of these. Registered or incorporated companies, companies limited by share, companies limited by guarantee. We discussed already earlier. So article of association of the company states the number of members with which the company is to be registered, right? Such a company is called company limited by guarantee. Unlimited companies, section 12 gives choice to the promoters to form a company with or without limited liability. On the basis of number of members, a company may be private or public company. For private company, 50 limited members is up to 50. Now it has been increased to 200. This has been changed, right? Public limited companies, 7 to unlimited shareholders can be there. Minimum has to be there. In case of private, it has to be 2. And for public, it is 7, right? Maximum unlimited in case of public limited companies and 200 in case of private limited companies. So number of directors, 3 directors can be there. Appointment of directors, they can be appointed also, right? So name of the company can be decided, but limited has to be used. Issue of prospectus, that is a combination of certificate of incorporation, AOA and MOA, Memorandum of Association and Article of Association. So quorum and special privileges are decided there, right? Managerial remunerations. Commencement of business. A private company may commence its business immediately after obtaining a certificate of incorporation. A public company cannot commence its business until it is granted certificate of commencement of business. So public limited company cannot commence business until it's granted a certificate of commencement of business. So it is required in case of opening of public limited company. So what are the privileges of private company? And a private company may be formed with only 2 persons. It can commence allotment of shares. It is not required to issue a prospectus also. Restrictions imposed on public companies regarding further issue of capital do not apply to the private companies. When a private company becomes a public limited company, so this is very essential. Private company shall become the public company in the following cases. By default, when it fails to comply with the essential requirements of the private companies provided under Section 3. A private company which is a subsidiary of another public limited company shall be deemed to be a public company. Where not less than 25% of the paid up share capital of the private company is held by one or more bodies, right? That is beneficial owner, corporate, such private company shall be converted into public limited company. When the average annual turnover of a private company is not less than 10 crores during less than relevant period, such a private company shall become a public company after expiry of the period, right? So if the turnover goes beyond 10 crores. When a private company holds not less than 25% of its paid up share capital of a public company, the company shall become a private company shall become a public limited company, right? Or when a private company accepts an invitation made by advertisement of receiving deposits from public other than its members, directors, that it shall become a public company. When public starts investing, accepting deposits, giving deposits to the company, private company is converted into a public limited company. And it can be converted also by conversion also, right? So article association may have that clause how it can be converted into a public limited company. On the basis of control, a company may be classified into a holding company or subsidiary company. Holding company, company is known as a holding company of another company if it controls over the other company. According to section 4, a company deemed to be a holding company, right? If it is holding more than 50% of the normal value of the issued equity, by holding more than 50% of its voting rights, or by securing its right to appoint a majority of the directors of the company, right? Subsidiary company, a company is known as a subsidiary of another company when its control is exercised by the latter, right? That is called holding company. So there are certain government companies where the shares are held by the government, majority shares, right? So national, on the basis of nationality of the company, Indian companies, these companies are registered in India. The Indian companies are registered in India under the Companies Act. Foreign companies, it means any company incorporated outside India which has established place of business in India. So we are just covering basic features. We are not going very much into details, right? So registered company, public company, holding company, unlimited company. A company not having any limit on the liability of its members is called unlimited company, right? Company, a company means a body of individual associated together to form a common objective, which may be to do a business for profit or for some charitable purpose also. Registered firm, which is registered with registrar of companies. Public company means a company which is not a private company. And holding company, we discussed more than 50% of the shares are held by the majority. Company shall be deemed to be holding company to another if that is in subsidiary. So incorporation of companies, company has to be incorporated, right? So what is the capital? What is the certificate of incorporation? Commencement of business in case of public limited companies. So private company can start its business as soon as it obtains a certificate of incorporation, but in case of public, it has to obtain a certificate of commencement of business, right? So promoter cannot be allowed to make any secret profit. Promoter is not allowed to derive any profit from the sale of its own property of the company unless all material facts are disclosed, right? Incorporation in the second stage of company's formation is a registration that are being company into existence. It has to be registered. To find out the registrar of companies whether the name by which company has been started is available or not. So I think online it is all available nowadays. So we have memorandum of association properly stamped, duly signed by the signatories of the memorandum of witness, article of association if necessary, a copy of agreement if any, a written consent of the directors to act in capacity if necessary, and statutory declaration stating that all legal requirements of the access prior to incorporation has been complied with. So just basic features we are discussing. We are not discussing each and every point here, right? To capital subscription, who can subscribe to a capital? A private company can start business immediately after the grant of certificate of incorporation, but public limited company has to further go through capital subscription stage and commencement of business stage, right? So this is all basic feature is that. Let's not go into very much detail. Commencement of business, right? So private company can commence, just a repetition again, and public can commence business only after getting that certificate. And it is issued by the registrar of companies, which is conclusive evidence that company has completed with all the legal formalities and it is legally entitled to commence business. Memorandum of association. So preparation of memorandum of association is the first step in the formation of the company. It is the main document of the company which defines its object, why it is being formed, for which business it is being formed, in future what all business can it do, and it governs the relationship of the company with the outside world, defines the scope of the activities, right, the business. So this is all there. The memorandum of association enables the parties dealing with the company to know with certainty as whether the contractual relation to which it intend to enter into company is within the object of the company, right? So, right, that is there. So, contents of the memorandum, what does it contains? Name clause, what shall be its name. To various clauses I'll discuss very briefly here, right? So, what shall be the name, right? That is the registered office clause, where will the registered office will be. Object clause, for which business it is being formed. Main objects, other objects, it will be defined here, right? Capital clause, how much capital can be invested. The capital with which the company is registered is called authorized or nominal share capital. Nominal capital is divided into classes of shares and their value as mentioned in the clause. So these are various liability clause, whether the unlimited liability, by shares or by guarantee, right? So this is all there. And alteration can also be made to memorandum of association, change of name, then change of registration office, right? The difference between memorandum of association and article of association. It is a charter of character of the company, including MOA, nature of business, capital. It defines company, its relationship with the outside world. It defines the scope of activities of the company. Article of association, regulations for internal management, rules of management of the company, subsidiary of the memorandum. They are rules for carrying out the objectives of the company. So, memorandum of association is a supreme document, and there should be, if there should not be, the memorandum of association will overrule in case there is a dispute between articles and memorandum. Every company must have its own memorandum. A company limited by shares need not have article of its own, right? So in such case, this is applicable here. On registration of memorandum or article of association becomes public documents. These documents are available for public inspection either in the office of the company or in the office of the ROC, Registrar of Companies. Every person who deals with can go through all these documents. So this was briefly all about various features that we have discussed. So I have not gone into very much detail, very briefly. So promotion, promoters, preliminary contract, certificate of commencement of business we have discussed in detail. So public limited company issuing a prospectus. No public company having a share capital is and issuing a prospectus inviting public shares shall commence a business. Borrow unless it obtains a certificate of commencement of business, right? So at least minimum subscription has to be raised. Every director of the company has to be paid to the company. Public company not issues a prospectus. Where a company having a shares capital does not issue a prospectus, business exercise may borrow powers if the following conditions are fulfilled. A statement in lieu of prospectus has been filled. Every director of the company has paid to the company. There has been filed charge with the registrar duly verifying declaration by one of the directors of the company. So in that case, prospectus is not required. A statement of prospectus may be sufficient. Right? Failure to commence business. So public limited companies, they have to commence within 1 year, otherwise they'll be shut down by the registrar of companies, right? So when an offer is made public to IPO, first allotment of shares, registration of prospectus, minimum subscription has to be mentioned in the IPO, right? Debentures, company is composed of certain persons who constitute a corporate body. That a member and shareholders are used under interchangeable by the Companies Act. A person who signs company's memorandum of association immediately becomes the member on registration of the memorandum of association, right? So before any shares are allotted to him, he becomes a member. Person who transfers his shares continues to be a member. A person who ceases to be a shareholder by any reason for future may be held liable as a member. A company limited by guarantee and limited by guarantee may have no share capital, will have members but no shareholders. A A person having a share warrant is also shareholder. And difference between members and shareholders. So, difference between members and shareholders. Term member and shareholders have been used interchangeably by the Companies Act. The word shareholders is used a relationship company share capital and there can be no membership except through the medium of shareholding. A holder of share becomes a member only when his name is entered in the register of members. But the term member is a wider in scope and may be used in relation to all types of companies. A member, capacity, how does he become a member? And we discussed earlier also, right? So he is having a more power than a shareholder. Minor, a minor can be a member of the company because contract with a minor is voidable and not void. But under Indian law, a minor being incompetent to contract cannot become a member of the companies because the contract with the minor is absolute void here in our country, right? So minor cannot be a member of the. Since partnership firm has no legal personality, it cannot purchase shares in a company of its own. Persons taking shares in fictitious names cannot be there. Hindu or divided family, shares can be held in the name of Karta only. Foreigners, NRIs, foreigners can become member of companies registered in India but permission of RBI as per FEMA 1999 has to be obtained. Insolvent cannot be, he is incompetent, right? Pawnee, in case of pledge, the owner remains with the pawner. So again, that is a charge created. And mode of acquiring membership, a person may become member in a company in any of the following types. The duties and liabilities of its members. It is a subscriber to the memorandum, pays all valid calls to take shares when they are duly allotted to abide by the decision of the majority. Liability, it is unlimited, limited to its shares or limited by guarantee. The right to receive copies of balance sheets. The members have far more greater rights than the shareholders, right? So that is obviously. So they can inspect any documents, they can receive notices, they can write to give copies of memorandum of association to prescribed fees, right? They can statutory report, right to transfer shares, right to receive dividends when declared by the company, right of participation or appointment. So this is all there available to the members.